Good evening and welcome to the Hedberg Public Library. The library is pleased to be partnering tonight with the Janesville Toastmasters Club in presenting a series of public speaking pointers from community leaders. We, along with the Toastmasters, believe that good communication is a key to personal and professional success. I'll ask Yuri Rashkin, who approached the library about this series, to introduce our speaker for tonight. Thank you.
Hi, everyone. I am proud president of Janesville Toastmasters. I am a little surprised that we're actually able to be here tonight because I was expecting, with all the weather-related emergency we've had, that we're going to have at least a tornado to stop us, but here we are. So thank you very much to all of you for coming. I'd like to thank the library for being interested in this project. I'd like to talk a little bit about the Toastmasters. We are a community club that is open to everyone. We meet on first and third Tuesday of every month at 7 o'clock in the evening. And it is a club that is for people who are interested in improving their public speaking skills. We are not members of it because we're good at it, but because we want to get better. And that is an ongoing adventure for all of us. Some people have been in the club for many years, some are recent joiners. As I thought about the ways that we could improve our public speaking skills, I thought that the best possible way is to learn from some great speakers. And we have some great speakers in our community. And I approached some of them, and they were very, very kind enough to agree to speak. And it is my honor that our first speaker tonight is Margery Tibbetts, who is an attorney with Brennan, Style & Basting, a law firm in Janesville. She is a 1989 graduate of University of Wisconsin Law School. She's a community activist. She's a great speaker. And I thought that we would want to have, as part of our group of speakers, we're going to have an attorney, we're going to have an educator in Dr. Tom Everett, who is superintendent of Janesville Public Schools. We're going to have a professional speaker, corporate trainer Rick Brunton, and we're going to have a lawmaker, our state representative Mike Sheridan. So I think this is going to be a great group from which all of us, and I certainly, can learn a lot and look forward to. So without further ado, I'd like to please help me welcome Margery Tibbetts.
Thank you, Yuri, and thank you to the Toastmasters and to the Hedberg Public Library for sponsoring this event. It's my pleasure to be here, and I'm glad we didn't get snowed out again this morning. Was worried about that this morning. As Yuri said, I'm an attorney at the Brennan, Style & Basting law firm here in Janesville, and I have been practicing law for 19 years. And to give you a perspective of where my public speaking comes in, I do civil trial work, which means that I'm trying cases, but most of my speaking engagements are pre-trial activities, such as going to depositions where we're asking witnesses questions under oath, or we're going to the courtroom and appearing in front of the judge and asking the judge to rule on certain procedural issues or certain issues in the case before we get to trial. And many of the cases don't go to trial these days for many reasons that don't have anything to do with public speaking. So when you see these TV shows where the lawyers meet with their client, and the next segment on the TV show, they're in the courtroom and they're giving these verbose opening statements, that's not reality in the law. That's not how it works. So many lawyers, such as myself, aren't in the courtroom like you see on TV. It's very different than that. We don't give a lot of speeches. Our practice and our public speaking is more like getting ready for a debate. I'll give you an example. When we have a motion hearing, we're asking the judge to maybe exclude some evidence from the trial, or we're saying, Judge, here's all the facts, and based on these facts, you should rule on my favor or in our favor before we even have a trial. And when we get to that motion hearing, we've submitted briefs, and we've told the judge, here are all the facts, here's the law, here's our legal arguments. And when you get into that courtroom, you don't know how prepared that judge is. You don't know if that judge has read all your materials. And if the judge has not read your materials, when you walk into the courtroom, you have to be prepared to start at square one and succinctly and respectfully educate that judge. Tell that judge what the case is about, what the facts of that case are, and what the law is, and say, Judge, rule in my favor. Sometimes you walk into the courtroom, and I'd say that's true with most of the judges here in Rock County and around the state, you walk into the courtroom and the judge has read all those materials. The judge knows what you have to say, but then they're going to take you to task. So you walk in with an outline and you're prepared to tell the judge all these things, but the judge will interrupt you and say, hey, Ms. Tibbetts, but what about this quote in this case? How do you respond to that? So rather than having an outline and a speech, you have to be on your toes and ready to respond to those questions. Or you may be in the middle of your presentation and adverse counsel interrupts you and they object and they say, Tibbetts is horrible, she's misrepresenting this, or the law doesn't really say that. So you have to be ready to respond to that. You have to know the facts of your case very well. You have to know what the case law says and why you're right, and respond to anything adverse counsel says or anything that the judge asks of you. So in my business, the lawyering business, rather than having an outline and a speech that you're either going to read verbatim or you're going to get up and give the speech, you have to have a very strong base and a very strong knowledge of your case and be ready to roll with the punches. So in preparing for any speaking engagement, whether it be for a deposition or any type of court appearance, the best preparation is to know your case, know it backwards and forwards. Go through the deposition transcripts, go through your investigative file, know the facts, have that down pat. Know the case law and have all the cases organized in front of you in a fashion where you can flip to whatever sites you need to show the judge or adverse party why you're right. So your preparation is to have all of those bases there in front of you, know where they are, and to know how to respond to any inquiries and be prepared for either scenario that I told you about. I do have a story. I appeared in front of the state Supreme Court with one of my partners, and when you appear in front of the state Supreme Court, you have an outline and you want to make your point, and they time how long you can give your presentation. And you're sitting at a table and you look up and the Supreme Court judges are sitting up looking down at you, kind of like the Wizard of Oz. And it's, I think, an intimidating scenario as it is. And then there's a light on counsel table and you have a certain time to give your presentation, the light goes off and you're done. And my partner and I gave our presentation and the adverse attorney got up and you could tell he had this long, very detailed outline and he was just glued to his outline and he was not going to leave that outline. He was just going to read it word for word for word. Well, the first judge interrupted him because they'll start pounding you with questions. You may get halfway through the first sentence of your outline and they start nailing you with questions. He was wholly ill-prepared for that. And he did not respond well to the questions because he was only going to argue from that outline. And he had no flexibility to go outside of that outline. And you could tell that there was some frustration from the judges as they were going through that because they would ask him a question, and rather than responding to their inquiry, he would go back to his outline and just read something from his outline. And at the end of his presentation, he picked up his outline and he said, I don't know why I bothered to prepare that. So that just gives you an illustration of how to and how not to prepare in my business for your court appearance. And I know one of the areas or the topics Yuri told me you're interested in is how to deal with the nervousness. And when I was a young attorney, way back when, that was back in the days where women attorneys still wore the skirt suits, and that was the style, and the real high heels. And I remember I used to walk into the courtroom and I would just shake. You know, my heels would shake and I'd get all red, and you'd sit down at counsel table and you'd pick up your pen and your hands would shake. So I learned really early on that I had to do things to adjust my attire or what I did before I went into the courtroom to try to, even if internally I was shaking, I did not let my audience know that I was shaking. So I would wear lower heeled shoes, and I would always sit. I wouldn't stand because I knew if I stood, I'd start to shake. And I knew I shouldn't drink a lot of coffee, because if I drank a lot of coffee, I'd get blotchier and shake a little more. So those were all things I learned early on. And then another mistake I think I made when I was a young attorney is you're in the courtroom with seasoned attorneys, and you would see how, especially if you worked under a certain attorney, you thought you had to be like that attorney. You thought, well, if that attorney has that style, I need to be just like him or just like her. And so I would try to mimic or be like some of the attorneys I worked for, and it took me many years to figure out and to gain my own confidence to realize I have to have my own style. I have to be myself. And so once you practice, or I practiced law for many years and got into the courtroom a lot and got over some of those initial things, the shaking and being nervous about being there, it finally clicked that, number one, I have to have confidence in what I'm doing. I have to know my case really well, just as I discussed earlier. And I have to feel really confident about what the law says, but I learned, yes, I have to be myself. I have to have my own style. I can't mimic what the other attorney is doing. And if I do that, then I'm not going to present well. Once in a while, cases do go to trial. And the opening statement at the beginning of the trial, this is what you see on TV, is where the attorney has the opportunity to tell the judge, if it's a trial to the court, or tell the jury what the case is going to be about and what evidence they're going to hear, and how we feel that they're going to view the case when the case is all said and done. And that's the one time, I think, in our business, or my business, where you have an opportunity to give a speech uninterrupted. And again, that's an area where an attorney such as myself needs lots of experience before you get comfortable with that. Again, my first few trials, I used to think I was going to throw up before I walked into that courtroom. And you'd walk in and you see all those jurors looking at you, and you know they're going to be listening to every word you have to say and criticizing every word you have to say, and you know you're in the courtroom with an attorney that's practiced double, triple time as long as you have, and they're a pro. And that used to be a very intimidating experience as well. But again, over the years, I learned, number one, you have to have confidence in your own abilities, confidence in your case, and again, your own style. And early on, as a young attorney, I made the same mistake as the attorney I told you about with the Supreme Court experience. I used to write out my outline, and I used to think, I just have to be glued to this outline, and I would just read off what was on my outline pretty much word for word and stand behind the podium like I am now, and I would be glued to my outline. And that's another, after many years, I learned I have to know my case so well when I walk into that courtroom and give my initial presentation in my opening statement or the closing statement, which is when you summarize what transpired, that I should just have snippets on my outline, some headings, the big picture points. This claim, and then under that I put bullet points. This is what you heard. And I just put one or two words to prompt me. And I've learned to not be glued to this outline and make sure that this outline is just a crutch I can go back to. It's kind of a checklist. but kind of have it on the side of the podium and know the case so well that I can, when I'm talking to the jury, I can get away from this podium, get out and talk to all the jurors, look them in the eye, and let them know that I'm very sincere about my case, make sure that they're following me, and that I'm so invested in my case and my client that I don't need to rely upon this outline. And another trick I've learned over the years, and I don't know if it works for others, I haven't talked to other lawyers, but whether I'm preparing up for a motion hearing, whether I'm preparing for a deposition, I'm preparing my opening statement or closing statement, I rewrite my outline many times. And I just write it over and over and over. And that way, I've written it so many times, I think it's ingrained in my mind. The subjects are ingrained up here, and I've thought about it enough that when I get up, I can give a more natural presentation rather than having to awkwardly rely upon my outline. And I found another thing I do, especially when you're getting geared up for a motion hearing or you're getting geared up for a trial, is you tend to get consumed by the case and you're thinking about it all the time. So I always keep a pad of paper with me, whether it be a large pad or a small pad, and if a key thought or a really good argument comes to mind, I will write that down and make sure that I've added that to my outline. So I think in my preparation, I'm constantly thinking about these things. Another thing which may be different from other public speaking in the lawyering business is we are dealing with high emotion. We're in contentious situations. Sometimes the environment is hostile. And I've learned over the years that I'm going to make a better presentation if I stay cool and calm. Sometimes if the other attorney is being very, very contentious, sometimes they make personal accusations. They try to steer you off course. They make accusations about your client, and they're hitting the podium and saying horrible, horrible things. Your human nature is to start fighting back. Okay, you're going to put on the boxing gloves. Well, I'm going to box back. And I don't think I make or anyone makes a good presentation to the court when you start behaving that way. So it took me many years to learn that I have to gulp really hard and hold that desire to punch back inside and just stay really calm and make my presentation and be very, very calm. Another thing I learned, it's kind of superstitious for me. I don't like to have a lot of distractions on the table in front of me, and one of the distractions I do not like are pitchers of water or glasses of water or a soda can. And that superstition came many years ago. I was arguing a motion with one of my partners, and he got up to make an argument, and he's very impassioned about his argument, and he picks up the pitcher of water and has the water glass, and he's going on and swings his arm, and the water went all over counsel table. So here he has all of his notes. I have my notes. I'm writing notes to him about arguments to make, and the ink is running off counsel table and dripping. But one thing is I think as I look back on that situation, besides it being a superstition for me, is he knew his case so well, and he was so confident that despite this disaster that was going on at counsel table, he did not miss a beat. So I was the panicked associate next to him, shaking the notepad off, but he knew his case so well, despite his blunder, which would be embarrassing, he just went straight on and made his presentation. Oh, another comment, I know Yuri again had mentioned, talk about how to deal with being nervous. I'm in the Janesville Noon Rotary Club, and every month we have students of the month who are honored by our club. and every student has to get up and give a presentation about themselves. And the last meeting I was at, one of the students got up and said, "Oh, I'm just so nervous. This is just horrible. I'm nervous." And the whole speech he kept saying, "You know, I think I'm doing okay, but I'm nervous." And every adult that got up to speak after him, members of our club, prominent business leaders in this community, all got up and said, "You know, all of us experience some anxiety, even us now when we get up and speak." And I think that that's just human nature. Even the best speakers, probably, and community leaders all experience a little anxiety before they get up to speak to a group, and it's just getting used to that anxiety and learning how to temper it and control it inside of you so your audience doesn't know. So if you have any questions, the reminder is if you have a question to come around and up to the microphone and ask your question.
I was curious, when you're speaking to a jury, for instance, and you have a group of people that you're speaking to, how do you approach the eye contact? Do you concentrate on one person and look at them, or do you find that it's better to look around? If you could talk about that a little bit.
I find it's better to look around. Number one, I like to look around to judge whether or not they're buying my story. If they're listening to my version, if they're agreeing with me, because I have found when you're in front of the jury and you're looking around and talking to them, especially during the closing argument, you can see if you're getting the nods, are they identifying with you? It's no prediction as to whether or not they're going to rule in your favor at the end, but I do try to get up and make eye contact with all of them and not single anybody out.
I have one question on my mind, because you do your own speaking on your own behalf and on part of your client. What advice do you give to your client on how to, the best advice you give for them when they're speaking in the courtroom?
Number one, the best advice is to tell the truth. Number two, only answer the question they've been asked. If they can answer with a yes or no, yes or no. But in order to prepare, I will have an outline of their testimony ahead of time. Let's say we're going to trial. I'll have an outline of what I want to present, and we will do a mock presentation and go through it many times so that they feel very comfortable with the flow. Because I'm in the courtroom a lot, so I have less anxiety, but for many of these people, it's the first time they're going to get up, but then they're going to be sitting up and people are going to be staring at them. And not only are they speaking in front of other people, but they have something at stake. You know, their livelihood, maybe they could lose money, there's something that's going to affect their life permanently or their business permanently. So they have that level of anxiety as well. So we will play act it. We'll go through it many times, and oftentimes I'll bring one of my law partners in, and beforehand I will have discussed the issue with one of my law partners, and they will do a mock cross-examination of the person so they can handle that cross-examination well, or as best as they can.
But when going to school for being a lawyer, do you have to do certain classes that teach you communication skills, like how you should be in a courtroom? And do you do certain like nonverbal things that they say might like help, like you make a statement if you really want to say something that you really believe in? Do you do certain like nonverbal things that like put a point across?
If you desire to be a lawyer, there's two communication skills you have to be very good at and have a very good base through whatever classes you can get at school. Number one is your writing communication. The written communication is usually the number one impression you're going to make to opposing counsel and to the judge. A lot of what we do is in the written form, so make sure you are a very, very strong writer. So whatever classes you can take where you get considerable writing experience and develop your own writing style and even have research experience And I think that's number one. And then number two, whatever classes you can get where you have the ability to speak. But otherwise, I don't think there are any specific cases or classes you should be taking. But I would, adding on to that, I think one of the biggest problems we're seeing with the more recent graduates from law school is that they do not have good writing skills. That seems to be a problem that many of us more experienced lawyers are noticing that's coming out of the law schools, is people just don't know how to write well anymore. And I think if you write well, then you can speak well. And that's another thing I should add. With modern technology, many people are now drafting their own documents or their own briefs as attorneys and typing everything. And my personal view, and other lawyers may disagree with me, I would prefer when I'm drafting a brief or another document is to continue dictating, because I think that trains me to learn how to take my thoughts and my organization and have it come through my brain and out my mouth. But when lawyers are drafting their own documents, they're typing and it's coming out their fingers. And so for me, the practice of dictating helps me practice verbalizing and organizing my verbal communication and arguments. I don't know if I personally do. People probably say they can read me like a book because I do certain things. I haven't really concentrated on that. I think more of it's the composure, making sure that to do the best job for your client and to present your case, you're as confident as possible. So whatever you feel comfortable with, to portray that you are confident, and to decrease, the signals to your audience that you're nervous. I would say the negative nonverbals are the shaking or the blotchy or being unsure of yourself. And I think it just goes back again to the confidence and a lot of experience too. And as many opportunities as you can to speak.
I'd like to ask you two questions, kind of related, kind of going to the theater of the courtroom, because you have witnesses who are coming in with certain expectations of what they're thinking. They've seen these, it hasn't just been Perry Mason, they've seen all these courtroom dramas and they know what the court is supposed to be like. Do you find that it's better to take a simple approach and a storytelling approach, or when you're using an exhibit, do you tend to try for a more high-tech approach, or how do you resolve a lot of these different issues when they've seen that in terms of their expectations? Do you try for more exhibits, or do you find that they're somewhat counterproductive? I realize it kind of depends on the case and all, but I'd like to hear your comments about that area.
Well, it depends on the case, and before you go to trial, most of the witnesses have been through either an interview process with me or my investigator. If they're a favorable witness, a friendly witness, they've come in and met with us. And oftentimes, if they're a friendly witness, we will do the same play acting that we have done with our own client and prepared that witness. So we know what that witness is going to say, and we want to make sure that that witness is comfortable, and we've gone through an outline with them so we have a good rapport and a good flow when they're up on the stand. If the witness is hostile, usually if we've done our job, we have either subpoenaed that witness and deposed them, or the other side has produced that witness and we've deposed that person. So we know what they're going to say. And if they're hostile, obviously we want to catch them up with stuff they've said in their deposition. With high tech, again, it depends on the case and the presentation. Are you making a presentation to just a judge? Are you making a presentation to the jury? And it just comes down to the nature of the case.
Okay. Thank you.
And sometimes pictures speak louder than words, so depending on the case, you may want to make your presentation with many photographic pictures and blow them up, and sometimes that catches the jury's or the judge's eye more than what the person is describing. So it just comes down to what the claim is, what the witness has to say, and what the nature of the evidence is.
I have a question about overall preparation and all the information that you have to know. And you did mention writing an outline and rewriting it so that you're very familiar with the information. But when you have all sorts of information dealing with a case, what are some other ways that you teach yourself the information? Because I teach research strategies, and I teach some public speaking units, and I coach forensics. And one of the biggest issues, even with myself when I speak, is just knowing the material and different ways that I can train myself to get everything down. So what are some different strategies that you've tried?
One of the things that I do, for example, if I am going to need to reference quotes out of a deposition or out of a trial transcript, and or I'm going to be referencing and relying upon quotes from a case, and they're too long to memorize. Whether it's a really complex matter, there's just too many to memorize. What I'll do in my outline is I'll use a highlighter, and I'll write C Exhibit A, or make some reference to myself and highlight that, and then I'll have all the exhibits that I need to rely upon. If I need to quote out of a document, I'll have them all organized with tabs on them and highlight what I need. So I have my outline here, but then I can flip to whatever that document is or whatever contains the quote, and I can pick that up and it's highlighted, and then I can read it. So that's what I do, and then I'll usually have the documents on one side, and then if I have case law that I need to rely upon, I'll organize it in the same fashion, like A, B, C, D, or 1, 2, 3, and have it highlighted. And I may say in my outline, quote, page 15 from Smith versus Jones here, and then I'll have that case right there, so I can pull that up and say, Your Honor, here's the quote, and I'll read it. So.
Thank you.
Sure, and I'll go through that again several times, make sure I have it organized and I've read through it and know it.
It sounds like staying cool and rational is one way that you maintain or establish credibility. Are there other ways that you use to establish or maintain credibility, or ways that you coach your clients in that way?
Well, you wish you had a magic wand so you could have your clients or a witness perform exactly the way you want them to. But again, I think it comes down to the practice with the clients or the witnesses practicing and going over it. But oftentimes things don't happen the way you planned. You know, the witness may be very, very well prepared, but they just go off on a tangent and say something absolutely horrible, and you have to learn to just internalize that punch and stay calm and keep a good poker face. And you notice some attorneys don't have a good poker face, and when the witness says something really bad, they turn red and glare at them like, why'd you say that? And I think that just comes with years of experience, just to hold it in and not let them know. You can take them in the back room and beat them up afterwards, and I'm just kidding, but I think it just comes from years of keeping it internalized, and it goes back to being well prepared and being able to move on your feet, because if the witness or your client has gone askew and gone off some tangent, you can't just stick to your outline. You have to have been so well prepared that you know how to go around, ask some questions to, maybe correct the errors they've made or to soften the blow. So,
I would like to thank the library, thank Ms. Tibbetts for being here. Thank you so much for speaking to us.
Thank you for having me.